So we need to talk about a critical decision striking down a state's rifle and magazine ban that was just stayed. So let's break down what is happening. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. A lot of you guys know that 1st Phorm has amazing supplements, amazing protein powder, pre-workout, energy drinks, great apparel that I wear all the time, but also they're pro-freedom, pro-America. The owner, Andy Frisella, has a podcast that, talks about a lot of the same concepts and ethos that we share here on the channel, and they support the Second Amendment. So if you guys are interested, check them out using the links down below. And if you order using my unique links down below and you order $50 or more, you can get a free 4-pack of energy drinks. Now, as I mentioned in the intro, in this video, we need to talk about what is now happening in the critical cases challenging the state of Illinois' ban on so-called assault weapons and also their magazine ban. Recently, we received a huge decision from the District Court Judge, Judge McGlynn, which struck down the Protect Illinois Communities Act, also known as PICA. This all comes after the Supreme Court denied emergency review in a ton of these Illinois and rifle magazine ban cases. The Supreme Court did not want to get involved, and now we are kind of feeling the repercussions of that. Despite the fact that the Supreme Court did not intervene in these cases, Judge McGlynn eventually reviewed these on the merits, and then he issued a decision striking down the entire law on the final merits. So this was a huge win for the pro-2A side because he found that these rifle magazine bans did in fact violate the Second Amendment. The state of Illinois has now appealed these cases to the 7th Circuit Court of Appeals, and they asked for a stay from the 7th Circuit biased panel. The 7th Circuit has not been pro-2A by any means, and now the 7th Circuit has actually granted that stay on the decision. There's also some very interesting developments in this case where the 7th Circuit itself is saying that Judge McGlynn's decision is deficient in some ways and that they want him to correct it. And they have also thrown around the idea of maybe remanding it for a limited time period for him to correct that issue. And in his decision, once again, Judge McGlynn found that PICA is in fact unconstitutional and must be struck down in its entirety. However, in that decision, he also stayed the enforcement of his order for 30 days so that the state of Illinois could appeal to the 7th Circuit and then seek a more permanent stay if they wanted one from the 7th Circuit. Illinois did appeal and also request a stay from the 7th Circuit. So the state's primary argument is that Judge McGlynn misapplied Bruin and also did not follow the 7th Circuit's precedents in the Beavis case. So the state of Illinois is pointing to other circuit courts that have ruled in similar cases dealing with rifle bans and magazine bans, saying these other circuit courts have reached a similar determination. Therefore, you should also find that the state's bans on rifles and magazines are constitutional, and at the very least, stay what Judge McGlynn said. Now, also one of the interesting things with this appeal and the request for the stay is that the state of Illinois maintains the very hardline approach that these rifles and magazines are not arms at all, covered by the text of the Second Amendment. Now, in response to that, the plaintiffs argued that from the very start, the state of Illinois made a procedural error. They pointed out that under the federal rules, the state, like everyone else, was first required to ask Judge McGlynn, the district court judge, for a stay before they went to the circuit court for that stay request. The only time you could bypass that is if their request for the district court to grant this stay would be impractical in some way. However, the state of Illinois did not say at all that going to Judge McGlynn would be impractical, and they did not allege any of that in their brief to the 7th Circuit. So there was a procedural error made by the state of Illinois. And also important is this development that the 7th Circuit recently asked for all the parties to file briefs and memorandum on whether or not the 7th Circuit should remand the case back down to Judge McGlynn for a limited time period to revise his judgment. The 7th Circuit believes that the judgment issued by Judge McGlynn does not expressly state what type of relief is being given to the plaintiffs and what conduct the defendants are barred from engaging in. But despite all of that, despite the 7th Circuit even saying that potentially the judgment down below is deficient in some way and them contemplating wanting to send it back down for a correction, the 7th Circuit just issued an order staying Judge McGlynn's decision. In the order, the 7th Circuit states that defendants have appealed and they request a stay pending appeal. Plaintiffs have responded and defendants have replied. The parties also have filed memoranda addressing the problems created by the district court's noncompliance with Rules 58 and 65. Appellate jurisdiction exists notwithstanding these errors because it is plain that the district court is done with the case. Compliance with Rules 58 and 65 remains necessary, essential if any litigant anticipates enforcing the decision through the contempt power, and we trust that the district court will enter appropriate orders promptly without need for a formal command by this court. Defendants' request for a stay rests largely on the fact that the court already has held that the laws in question survive motions seeking preliminary injunctions. A decision at the preliminary injunction stage is not dispositive when the plaintiffs seek permanent relief. Our opinion indicated some matters that needed further exploration, but the analysis in Bevis shows that the laws have enough support to remain in place pending the final resolution of plaintiff's suit. Every other court of appeals that has addressed the validity of similar legislation in the wake of Bruin has come out the same way as Bevis. The laws addressed by those decisions differ in some respects from the Illinois statute, yet the absence of support in other circuits for the district court's disposition lends straight to a conclusion that the Illinois statute should remain in force until final appellate resolution. At least 2 other essentially identical suits are pending in other district courts within the 7th Circuit. The 3 suits were addressed jointly in Bevis, and they must be resolved the same way eventually. This does not necessarily imply that the 3 cases will again be consolidated on appeal. We are reluctant to delay disposition of this appeal indefinitely just because similar litigation is pending in other districts. Still, the only way to preserve the status quo statewide is to enter a stay in the suit. The judgment of the district court accordingly is stayed. The stay will remain in force until the court has issued its mandate. So the 7th Circuit is doing a few things there. First, they are saying we acknowledge the fact that we ourselves brought up a question about whether or not the judgment from Judge McGlynn was appropriate, if it needed to be remanded and corrected. But now they're going to glaze over that because they're going to run into the issue of if they say and they stick to the fact that there is an issue with the judgment, well, then you can't issue a stay on a deficient judgment. So they're saying, we're going to trust that he'll fix it. We brought up an issue with that. If there is an issue, we trust that he's going to fix it, and we're going to retain the power right now to stay that judgment. Oh, by the way, even though the fact that we said that maybe there's an issue with it. They're also saying that they need to stay the decision here because it's for the best interest of the public at large, because the public's at risk because of these scary rifles and magazines. And then they point to other decisions in other circuit courts that have come to a similar conclusion. Now, some may think that the plaintiff should challenge the stay that was granted by the 7th Circuit and potentially seek emergency review from the Supreme Court for the removal of that stay. However, I'm just going to state here that even if that does happen, if a request is sought for an emergency application, it's going to be likely very hard to get the Supreme Court to step in on an emergency basis to remove that stay, and likely any emergency application at this point would be denied. There was also a hint there where the 7th Circuit in this case is talking about maybe stalling this case out for a little bit for the development of some of the other cases that are trailing behind this and then maybe consolidating them. They said that, we're not necessarily interested in delaying this case, but it's interesting that they threw that in there, which might actually hint that that is actually what they're going to do. So ultimately how this pans out is the Judge McGlynn decision, which struck down the Illinois rifle magazine ban, has now been stayed indefinitely, at least until the 7th Circuit rules and decides on this case. Again, there are options to get around that and to seek Supreme Court intervention on an emergency basis, but again, that's going to be an uphill battle, and I don't anticipate that even if that's requested, that the Supreme Court will step in on an emergency basis, because in this case and other Illinois cases, multiple times, the Supreme Court has denied emergency review. So that's what's currently happening in the Illinois rifle magazine ban fight. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, but as always, thank you all for watching. Don't forget to like and subscribe, and never forget that this station was built by Armed Scholars, and the station will be maintained by Armed Scholars.